Good afternoon, everyone. You can take your seats, we'll get started. Good afternoon. I'm Kerry Abrams, the Dean of Duke Law School, and it is my great pleasure to thank you for joining us today for this special discussion with the recipient of our 2025 Bolch Prize for the Rule of Law recipient, Justice Tassaduq Hussain Jillani. Each year, the Carl and Susan Bolch Prize for the Rule of Law is awarded to an individual or organization that has demonstrated extraordinary dedication to the rule of law and advancing rule of law principles here in the United States and around the world. The Bolch Prize was created by Carl Bolch, Jr., a 1967 graduate of Duke Law School, and his wife, Susan Bass Bolch, a graduate of Georgetown University Law Center, when they established the Bolch Judicial Institute at Duke Law School in 2018. They charged the Institute with a specific mission to better the human condition by studying and promoting the rule of law. This mission has inspired an array of educational programs and scholarly endeavors that aim to strengthen and support the judiciary and judicial systems here and around the world. We are delighted that Susan could be with us today, along with several other distinguished members of the Bolch Judicial Institute's advisory board, and as well as members of Justice Jillani's family. Please welcome all of our special guests. Justice Jillani is exactly the sort of person we had in mind when this prize was created. His tenure as a judge was defined by a steadfast commitment to the rule of law and his nation's constitution, even when that commitment required him to stand up to a military dictator or defy public opinion and social traditions. Justice Jillani has graciously agreed to share his remarkable life and accomplishments today in discussion with our own Paul W. Grimm, the David F. Levy Professor of the Practice of Law and Director of the Bolch Judicial Institute here at Duke Law School. Judge Grimm is a retired judge of the U.S. District Court for the District of Maryland, where he served as both a district judge and a magistrate judge for 25 years. One note before I turn things over to Judge Grimm: we are recording this discussion and we will post this program as well as the Bolch Prize ceremony that is taking place this evening on the Bolch Judicial Institute's website. Thank you all for being here. Now I'll turn things over to Judge Grimm.
Thank you so much, Dean Abrams, for that introduction, and welcome all of you, particularly Justice Jillani's family and friends, and I think a former law clerk as well, all the way from New York. So quite a tribute to you. It is my great pleasure to introduce Justice Tassaduq Hussain Jillani, who served as the 21st Chief Justice of Pakistan. And he is the recipient of the 2025 Bolch Prize for the Rule of Law. Justice Jillani has devoted his life to advancing, protecting, and standing up for the rule of law, often at great personal risk. And his story seems particularly important at this time in our own country, frankly. Justice Jillani began his professional career in 1974 as a lawyer in the district courts of Multan and the High Court of Lahore. He served as Assistant Advocate General and then Advocate General of Punjab before being elevated in August of 1994 to serve as a judge on the High Court of Lahore. In 2004, he was named as a justice of the Supreme Court of Pakistan, and he was Chief Justice for the last year of his tenure on the Supreme Court from 2013 to 2014. As a judge and justice of the High Court and Supreme Court, Justice Jillani wrote numerous opinions and judgments advancing human rights, gender equity, and modernization. His jurisprudence is impressive and includes opinions that protect religious freedom, declaring education a fundamental right, affirming the right of adult women to marry the person of their choice in Islam, establishing guidelines for improvements in legal and medical education and regulation, and holding that Pakistan should permit dual nationality in light of an age of globalization and interdependence. Now, in 2007, Justice Jillani was forced to leave the Supreme Court when he refused to take a new oath of fealty to then President Pervez Musharraf, who was serving, took power of the civil government in a bloodless coup and served in a joint status of the commander of the military in Pakistan as well as the civil leader of the country. In 2007, he made a decree that all justices should swear an oath of loyalty to a new form of government that had suspended the existing constitution and imposed a new constitutional order. Justice Jillani and other justices refused. As a result of that, was removed from the court. In 2008, however, General Musharraf was forced to resign, and what happened after the action that was taken when Justice Jillani and his colleagues refused to take the oath, the bar of Pakistan took to the streets, frequently, often, and bravely, to protest, and ultimately, President Musharraf resigned and fled in the face of impeachment proceedings. Throughout his career, Justice Jillani stood up for human rights, religious liberty, and the protection of judicial independence, not only in Pakistan, but speaking for that around the world. Justice Jillani, thank you for being with us today and the recipient of our prize. So, this is your life, as the old show used to be. Let's start at the beginning. What was it that attracted you to a career in the law? Was there a family member, a career in the law? Was there a moment of real clarity when you realized this is what you wanted to do? A mentor who helped you along the way? Tell us, what was it that led you to a path at the law?
What really inspired me, but to begin with, thank you very much for what you have said, for your kind words. And thank you very much, ladies and gentlemen, for being here this afternoon. To be honest, what inspired me to go in for law was my idealism to do something in public life. I remember I was, in those days, I was interacting with former President Kennedy. I used to write letter, and Robert Kennedy, he wrote a book, The Enemy Within. It was the inquiry entrusted to him and a committee, corruption in labor union. And I wrote him a letter, and he sent a copy of this book with his endorsement. But I thought that to play a public life, you have to have a standing, both socially and economically. And law, I thought, would suit that mission. So I joined law college, and I did my law. For a while, I was in politics. But then I found that on more than one occasion, one had to compromise. So I concentrated mostly on my legal profession, as a result of which I attained a certain credibility within the bar, within the government and judiciary. I was elected the youngest Secretary General of the bar, and then member of the Punjab Bar Council, and I became Additional Advocate General, and then Advocate General of Punjab, and eventually the government and the judiciary realized, and in 1994, I was made Judge of the High Court.
So had you, when you started and when you got into law, were practicing it, and you assumed higher positions of more responsibility and authority, was there a moment when you decided that you wanted to be a judge or that you were called to be a judge? Had you always thought this was something that you wanted to do? Share with us perhaps a little bit about how one becomes a judge in Pakistan and what led you to take that next step from practice to the bench.
After spending a couple of years in practice, I found that there were things that I could not help, and I could not dispense justice. I could not be fair. So I thought maybe as a judge, I can dispense justice. And I had an eye on being elevated as judge of the High Court. So once the Chief Justice of the province called me, and he sent my name, he recommended my name, which was approved by the President, and eventually the Prime Minister issued the notification. That is, those days the procedure was that the Chief Justice of a particular province in which the person has to be appointed as a judge used to initiate the name, and it used to go to the Chief Justice, and after his approval and approval of senior judges, the appointment used to be made to be formally notified by the Prime Minister.
Now, in the United States, in the state system, some judges are elected by the public. Some of them face retention elections, serve for specific terms. In the federal system, judges under the Constitution serve during good behavior, lifetime appointment. When judges are appointed in Pakistan, is there a term for each appointment, or is it for life, or is there some time aspect that governs?
No, we don't have the system of elected judges. To be a judge, there is a minimum age. Now it is 45. And the retirement age of a judge of the High Court is 62, and that of the Supreme Court is 65. That is the age when he attains superannuation and he retires.
All right. One of the things that I think that anyone who makes the transition from being in practice to being a judge finds that they look at things a little bit differently. I remember my own life thinking that when I got to be a judge that probably I had seen a lot of things and I had a pretty broad experience, and that I guessed that probably 75% of the cases would be pretty cut and dry and 25% would be hard. And boy, was I wrong. It was the other way around. It looked like 75% of the cases were very hard and 25% of them were a little bit easier. And my view of the rule of law and the role of lawyers changed significantly when I changed my status. So can you share with us, did your perspective on the rule of law evolve when you went from practicing to becoming a judge? You said that you felt that you wanted greater opportunity to do justice. You had that opportunity now. How did your perspective on what the rule of law is change when you became a judge?
You see, as a lawyer, one has to defend a case of a particular individual. You prepare the case and then you advocate the matter with a passion before the court. But when you become a judge, it's not the individual you're looking at. You have to have a bipartisan approach. You have to sift the facts, see what both parties are saying, and then decide where the law stands. When I was practicing law, I found that yes, I prepared my cases and advocated them with a passion, but then the ultimate justice was with somebody else. It was the court which had to administer this. I became a law officer. I became Assistant Advocate General, Additional Advocate General, and then Advocate General. But then, as an Advocate General also, I had to plead the case of the government, right or wrong. But at that time, I decided that the state is not an ordinary litigant. It is a repository of justice. So I distinctly remember I used to take issue with the government also that your stand is wrong, and I would not be able to plead it. that really created a certain amount of credibility, not only with the government, but also with the bench. I recall that in one case, while appearing before the court, I said, "Sir, I have instructions regarding this, but my view is this." So that way it really helped. And the judges, the court, started having faith in what I say. That really matters in the legal profession, your credibility.
I think that that's probably a lesson that we all learn, is that our reputation and our credibility before the court is probably the most important resource that we have as an attorney and as law. I want to turn to some of your opinions. You authored a number of groundbreaking opinions. I mentioned some of them about religious freedom and education as a fundamental right. Perhaps you could pick one or two of those opinions that you had that you think were particularly significant. Share with us sort of how the case proceeded before you, how you may have approached it. Now that you're retired, of course, and the cases are behind you, you can talk about them. You can't talk about them when you're still assigned to the case.
Yes, there was one case, the case of rights of minorities, which I think I always looked for a moment for a case on which I could pronounce my opinions. I was a very sensitive young man, and I found that we were not treating the minorities fairly. Our folks didn't treat them as equal human beings. So I thought these people have to be educated. But then I thought that I'm nobody at the moment, and what I say would not carry much weight. I was elevated as judge of the High Court, but still I wanted to be at a place where my opinion matters. Eventually, I was elevated as judge of the Supreme Court. I still waited, and lo and behold, I became the Chief Justice. It was at that time that I decided that I should give opinion on right of minorities. So I took suo motu notice of the wrongs being done to minorities.
And that's on your own initiative. That's what suo motu means, right?
Nobody petitioned for me.
Right.
I strongly believe that the court should take suo motu notice to take up cases of vulnerable communities which are, on account of their social and economic limitations, cannot knock at the door of the court. So it was that perception which persuaded me to take up the case of minorities when I found that a church in a city of Pakistan, Peshawar, was made a target of bomb blast, during which 81 Christians died and many got injured. Months passed, there was no compensation, and the culprits were not arrested. It was that time that I took suo motu notice. And during the hearing, I also received complaint of a tribe in northern Pakistan, Kalash tribe, which complained that we are receiving threats to change our faith, otherwise they'll face death. So I issued notice to concerned state functionaries, and after detailed hearing, I gave 7 directions. Creation of a special force for the protection of rights, for the protection of the places of worship of minorities, creation of a National Council for Minority Rights, creation of special curricula which should espouse pluralistic values in school and colleges. And I also gave declaration that the rights of minorities as stipulated in Article 20 of the Constitution are multidimensional. It is right to believe, right to propagate, and right to disseminate. So that was, in a way, a groundbreaking opinion, because since the creation of Pakistan, no court had given a judgment on Article 20, which stipulated the rights of minorities and which stipulated religious freedom. So I think this judgment was important. And I also felt that the courts gave declarations and passed judgments, but then ultimately they are, they found their place in law journals, but they are not implemented. So what I did there in that judgment, that I said that the implementation of this judgment shall be carried out by a 3-member bench of the court, and that bench, incidentally, is still functioning. People retired, but the bench continues to function. And that has helped the minorities. It has given them a platform, a voice. They can, simply go and file an application before that 3-member bench that we are being wronged, or this is a violation of the judgment. So that, I think, is important.
So that's an interesting point. When we look at the rule of law, sometimes it's looked at from the dimension simply that those people who exercise power are required to be subject to the law and not above it, that the law will have equal application. What you don't hear so much about the rule of law, which I think is essential, and I want to follow up what you just said about that landmark case that you decided on minority freedoms of religion, is that the rule of law in a democratic society depends upon the willingness of the public to accept a ruling from a court, even if it changes what they're used to, or even if they don't agree with it, that law binds them unless the law is ultimately changed. As I understand it, Pakistan is a democratic parliamentary republic. Islam is the designated state religion. Your decision recognized the authority or the obligation of the state to protect the freedoms of religious belief of people who did not. How was that? You set up a 3-person judge panel to hear cases, and that's still in place. But how did the public react? Was there a period of time in which this decision, this groundbreaking decision, was new and was talked about? Did they gradually adjust to it? And has it become accepted now over the course of time?
Well, in fact, the way it was, I was not expecting that this judgment would be accepted by and large. I was expecting a reaction, because one of the things that I said was that the right to religious freedom is multidimensional. It is right to believe, right to propagate. In an Islamic society or an Islamic country, some people believe that in Islamic State, the minorities don't have a right to propagate. They don't have a right to propagate their religion. But this declaration made by me was generally accepted, and there was no reaction, except 1 or 2 people. They said this is un-Islamic, but there was, by and large, acceptance. So that really gave me a surprise. Then I appreciate that it was widely acknowledged worldwide, and in some of the Muslim countries also. That's what it is.
So you saw a farther reach than just Pakistan with that decision that you made, because having established that precedent, other countries were able to follow it as well.
I don't know whether they are followed or not, but the feedback that I got was that they appreciated it. In fact, Judge Wallace once told me that he's organizing a conference of chief justices of Muslim countries, and I'll be invited. Okay, what's going to be the agenda? He said, your judgment.
Well, that is a far-reaching effect of a decision that was obviously a very important decision that resonates today in Pakistan as well. So oftentimes judges are asked, do you have a philosophy that affects your judging? Are there values, are there principles, are there approaches to judging that are unique to you? In our own country, we talk about people who are originalists in their interpretation of the law, others who are more flexible in their interpretation of the law. Some people feel that legal decisions should be very, very, very narrow and restricted only to the issues of the case, and that over time, incremental changes will develop a broader application of the law. Others feel that sometimes you have to strike boldly and make a pronouncement of law that may be a significant change. Do you view yourself as having had a philosophy or an approach to judging? And if so, could you share with us what that is and why you think that was important in your career?
Yes, I always believed that a judge, particularly of the Supreme Court and High Court, they have to decide the matter strictly in the light of the Constitution and its seminal values, and while laying down their opinions, they have a role to educate the people, because unless you have an educated citizenry, you cannot have an effective rule of law. So that way, the judiciary has to play a pedagogical role, and I always had that in mind. Secondly, I believe that the judge, there are situations in which the judge has to be a catalyst for social change. When I talk of that, the classic example in mind that comes to me is that of your American Supreme Court's case in the Board of Education.
Brown versus Board?
Yeah, Brown versus Board of Education, in which the Supreme Court did away with the segregation in schools and sent federal troops to enforce the judgment. So that was the court playing a role of a catalyst. So in similar terms, the judgment on minority rights, I had in mind that it should be a catalyst for social change, and that is why I gave 7 directions, which the aim was, the goal was that they should bring about social change. They should educate the people as to what the rights of minorities are, what the duties of majority are. That's what.
The need to educate in the delivery of a judgment so that the public can understand that seems tied directly to what your previous point was, is that the public needs to be aware of what it is that the court does, and even if they don't agree with it, they at least know the justification so that it's not just simply arbitrary.
I strongly believe that unless the public is educated, unless the public is conscious, unless the public is aware of the constitutional values, you cannot have a functional democracy, and you cannot have a rule of law.
So I want to go now to what I think was probably certainly the most dramatic event in your judicial career. And I kind of like to read from this wonderful law review article. Tayyib Qureshi, who is the past president of the Muslim Bar Association in North Carolina, wrote her law review note when she was at the University of North Carolina. And it was the state of emergency, General Pervez Musharraf's executive assault on judicial independence in Pakistan. And I want to read to set the stage for all of us in the audience to try to capture a moment of the flavor of what was going on there that had to have been a very challenging time. She says, on October 14th, 1999, Musharraf issued a proclamation of emergency declaring himself the chief executive of Pakistan and promulgated a provisional constitutional order to replace the 1993 Constitution. It suspended the National Assembly and provisional assemblies, prohibited the judiciary from acting against the chief executive, and in January of 2000, Musharraf ordered the judiciary to take a new oath of office by swearing to uphold the 1999 provisional constitutional order. Judges refused, they were dismissed, and later the court was constituted by judges who had taken that oath, and they ultimately approved the extra legal ways by which he had assumed power. And in 2007, this progressed to a similar event that involved you personally, when you and many judges refused to take an oath of loyalty to General Musharraf and were removed from the bench. I cannot even imagine what must have been going through your mind, your obligation that you felt that you had, your sense of responsibility and what was proper and not proper, but also your concern for your family. So tell us, can you help us understand what was going on at times, what the demand was, why it was that you felt that taking that oath was improper? And then I want to ask you about sort of what was going through your mind as that impacted you as an individual, as a father, as a husband, and what went through your mind as you struggled with making the decision that you thought was the right decision to make.
Well, when Musharraf took over in '99, I was a judge of the High Court, and I thought that the manner in which he took over was unconstitutional, but the matter was not before me. His action was challenged before the Supreme Court, and Musharraf pleaded before the court that I took over for X, Y reasons, and that I have certain goals to implement to develop the country and to eradicate corruption, etc. And the court validated the takeover with the caveat that he should hold elections within a certain period. Now, he held the elections, and under a certain scheme of law of his making, and he wanted to contest the election for the first time in 2007. And there was a challenge to his candidature, mainly on the ground that as Chief of Army Staff, while wearing uniform, he cannot contest the elections. His rival candidate was ex-Chief Justice of Sindh High Court and ex-Judge of the Supreme Court, Mr. Wajihuddin Ahmed. Now, the sheriff wanted the court to help him out. He called the Chief Justice and rather conveyed to him that this is to be done. He said, the case is not before me. The case was before a bench of which I was a member. And the precise question was, could a person in uniform contest the presidential election? So while we were in the midst of the case, he imposed state of emergency, prescribed a special oath of loyalty, and we were shocked. How could he do that? And I decided there and then that there has to be end to it. The good thing was that a great majority of judges were of the same view. So that really, our moral stand had a very positive effect on the bench, on the bar, and generally public. There were demonstrations countrywide seeking restoration of judiciary. And the American Bar Association, perhaps for the first time, came on the streets to seeking restoration of judiciary in Pakistan. The agitation and the demonstrations grew larger, and it was then that Musharraf realized that it was no longer possible for him to continue. And at that stage, the Americans also played an important role in persuading him to vote the elections. The elections were held, and during that period, Benazir was shot dead, killed. That further agitated the public mind. And the People's Party won majority. The civilian government took over, and Musharraf had to resign. It was thereafter that the judges were restored by the new government.
So what was it like having to weigh, knowing that you had a military dictator, a person who was wearing the uniform of the chief of staff of the military of Pakistan, and also had assumed the power of the president of the civil government, a person who obviously had a great deal of power and had not just simply the power of the office of president, but also the power of the military behind him, and to defy a demand that you take the oath under the new provisional order that he had signed. What went through your head? Were you concerned about your family, and did this create some period of indecision or struggle, or did you know that this was the right thing to do and you were determined to do it?
Well, it's a very good question, I must say, because there are a couple of personal stakes at that time. One was that I did not have my own house. I was living in a government house. I received a notice that you should vacate the house forthwith. But it was my family, my sons and my daughter, my wife, who stood up and said, no way, we are with you, whether house or no house. So that really gave me moral courage. And I said, this has to end. We cannot be taken for granted, the judiciary. And we must assert ourselves and declare, and we should stand by our oath. That is what persuaded us to take up the stand.
So it was a decision that you made, but it was also one that was shared by your family.
Absolutely.
And that must have given you a sense that you were doing the right thing.
Absolutely.
I want to talk about the role of the legal profession when this was going on. As you know, judges are limited to speaking their view on the law and what should be happening through the cases that they decide. And there are limits about what judges can do publicly, ethical limits that restrict a judge from talking about matters that are pending before the judge or that likely will be pending before the judge, so that they do not appear to be having already made their mind up on a matter that might come before them. On the other hand, lawyers take an oath to support the Constitution. Their profession brings them most intimately in contact with the courts and the law. And they do have the right, the ability, and I think most people view the obligation to defend the judicial system and the courts from unfair attacks. And that happened in Pakistan during that period of time. And I recall video of lawyers. They were all wearing the same. Their black suit, white shirt, black tie. They were not subtle. They were in the streets. They were making it known that this was wrong. This was an assault on the rule of law, which was greater than any one part of the government. How much did that influence, do you think, the outcome? Did that contribute to the realization that General Musharraf had that he had to finally step down? And how important was the support of the bar to amplify the decision that you and those fellow judges who refused to take the oath made?
You see, bar in any society, and more so in societies like Pakistan, has a pivotal role to play, because they're an educated class and educated in law. They take it as their stake to sustain the rule of law. And they started the movement, which really became popular among the public also. The public found that lawyers are an educated class. They don't represent any party, but they're neutral. They are fighting for a certain cause which must be just. And the demonstrations were so countrywide that Musharraf realized that he cannot continue. And then he found that the lawyers' movement was getting international support. The American Bar Association, the English Bar Association, some of the European bar associations, they came out in open to support the judges' restoration cause. It was at that time that the American Bar Association awarded its Rule of Law Award of 2007 to the judges of Pakistan who defended the Constitution under the rule of law. And I was invited to receive the award. These are heady moments.
You know, well, who would be more appropriate to accept that award on behalf of the judges of Pakistan than you, Justice Jillani? It puts me in mind of that old expression that perhaps it is true that the pen is mightier than the sword, eh? I want to now ask you to share your experience and your wisdom with us. And in this country now, we face some questions that are similar to the ones that you have handled before us. The roles of different branches of government, and particularly the role of the judiciary in declaring the law. Of course, the judiciary is the weakest branch. It doesn't appropriate its own money to operate, and it doesn't have its own enforcement arm. And it depends upon the public's acceptance and the support of the bar to maintain its legitimacy. Do you have any observations, any advice, maybe even some encouragement for us at this time in our history that you would like to share with us before I open it up for questions at this particular time? Any wisdom?
Well, I feel very humbled at this asking and this question that what advice should I give to the American people? All I can say is that the rule of law, the threat to rule of law is not confined to countries like Pakistan, and the Americans should realize this. They should watch out whether the rule of law is under threat today or not. And I trust the American public, by and large, is very educated, enlightened, and they'll make the correct decision. That's what I say.
Well, that's good advice, and we share that hope. Do we have questions? We have a few more minutes. Any questions from anyone in the audience? This is a classroom full of law students and no questions.
Probably just your microphone is a little bit.
Let me see. All right. Any questions? No questions? All right, sir.
Thank you for being here, Justice. I'm curious if you could speak more about how your commitment to the rights of minorities and kind of enshrining that in your judicial philosophy came to be. Were you exposed to injustices that caused that to be an issue of concern for you? What was it that caused that particular consideration to be at the center of your legal work?
Well, I said earlier on that in our society, minorities socially are looked down upon. They're certain. And that used to really pain me. And I thought that the Constitution gave them equal rights. The religion gave them equal rights. But we have social prejudices which make us, behave the way our public behaved. For instance, I'll just quote one or two incidents. People would not drink in a glass in which some member of minority community has drank. And things like that. So I thought that there has to be a declaration, there has to be a direction by the court to indicate that what rights minorities have under the Constitution and what the duties the government has in terms of protecting those rights.
There was another question over this side of the room. All right, Hugh, and then sir, we'll get you. Please.
Mr. Chief Justice, thank you for being here. I was wondering, as members of the bar, as members of the judiciary, ethics is such an important part of how we go through making decisions. Is there a place where you get a source of strength for making ethical choices, or a place where you go to know whether this is the right or the wrong choice in evaluating, a culture and society against a direction that the rule of law needs to move or needs to be protected? in the context of, where do you get your strength for making ethical choices as you look at hard problems, many of the difficult problems that you have written opinions on?
Okay. Well, the first was by the terms of my own. The first was the terms of my own oath. Which are to the effect that I decide the case without favor or fear. And then in our field, in Islam, a judge has a very exalted position. And that a very exalted office, and it is a very onerous duty of a judge to decide a case justly, irrespective of parties' faith or relationship. That was a second moral compulsion. And then the third was the constitutional provisions. When it came to Musharraf's case, we found that the Constitution did not permit a person in uniform to contest the election. We had taken oath under the Constitution, and we had to defend that Constitution. That was the third moral force.
Sir.
So I wonder if you could just share with us, for those who don't know much about India and Pakistan, who was one or two or three justices of the Supreme Court who preceded you whom you admired, and what did you admire about them?
The judge of the Supreme Court whom I admired?
If there are any individual ones that you particularly admired who preceded you, and what it was about them that you admired.
Well, there are quite a few. I admired Justice Cornelius, very fair judge. I admired Justice Kayani, fairness judge. I admired Justice Hamoud Rahman, fairness judge, and so on and so forth.
Was there some characteristic about them that led you to have that degree of admiration for them?
Their humility and their commitment to their oath and constitution.
It's interesting that you mentioned humility, because I think sometimes the public perception of judging and judges, the notion of humility does not enter into it. But I certainly, from my own experience, felt humbled all the time, because each case, the names of the people on the pleadings were not abstractions. It was their case, their issue, their freedom, their property. And to think that they are dependent upon you, and all of us have human frailties and shortcomings, to be fair and just and as quick as you can. And when you live with that notion of humility, if I could encourage judges to embrace that more, I think that would be a very good thing. One more question in the back. Yes, ma'am. Yeah, please use that courtroom voice.
Thank you. Justice Jillani, thank you so much for your words.
A little bit closer. You don't have to run. Please.
Thank you for your inspiring words. I wanted to ask regarding the impact of your opinion. You wrote, you just spoke on how the pedagogical aspects and the social justice aspects of the judiciary are something you feel very proud of and are extremely impactful for the public and for the law. And you mentioned in particular in the US context with Brown v. Board of Education. As of now, we just did Brown v. Board of Education in constitutional law. I wanted to ask you, should opinions be written, in that case in particular, it was written to be short, concise, and very clear, so that when it was published in newspapers, everyone, whether they had a legal background or not, would understand the ramifications and importance of the decision. And in terms of your decision as well, its international ramifications as well seem to have a lot of similarities. So should opinions be written for lawyers, or should they be written for the public? And in that sense, should they be long, extensive, more complicated, or would it help to have them be more clear, more short, more straightforward, so that issues that we're currently facing today can also be understood by the populace here in the United States?
That's the question.
Well, I believe that opinions and judgment is basically rendered for the public, for their rights, to explain their rights, to explain the issue involved, and of course the lawyers. The relevance of the lawyers is in the legal issues involved. But I think the quality of judgment depends on its clarity and how far the public understands that. And I said the court has a pedagogical role to play to educate the public as to what is Article 20, what is Article 25, so that the public should know what are their rights and what are their duties. It is only through educating the public that you can sustain rule of law and you can sustain democracy. If the public is not educated, they would not appreciate what XYZ has done, what Musharraf has done, and what in your case XYZ did and has done. The judgment should explain it, the rights, the duties. It should be understandable. That's my response to that.
Thank you very much. Well, Justice, I think perhaps afterwards there will be an opportunity, but we've come to the end of the hour. You want your law clerk to ask a question? That's a dangerous thing, to let your law clerk ask a question.
I don't have a question, but since I'm here, it's very emotional because I am seeing Justice Jillani after almost 11 years. I had the honor of being his law clerk, his ironically first and only law clerk. Also, inadvertently, I happened to become the first law clerk to the Chief Justice of Pakistan at the time that I was there. And there's been a lot of questions about how he interprets the law, so I thought I'd just step in and say something, because Justice Jillani is very modest, in case you can tell. And he is a master of interpreting the law. And I have worked with multiple judges in my career, and I've never met someone like Justice Jillani who can do what he does, where he balances being able to interpret statutes, the Constitution, but then, as you would ask the question about ethics, balancing ethics, and he is the epitome of doing the right thing. That is what he has always done. He stands by his morals and his beliefs above everything else. And it is a very difficult task to balance that with the law and with the cultural norms that we have in Pakistan and the religious aspects of it. And he does that masterfully. And that's all I wanted to say.
Thank you all very much. And if there are some other questions that were not yet answered, you come on down. We might have an opportunity to do that. But thank you very much for joining us.
Thank you very much.
That was wonderful, Justice Jillani.